Well, I don't know about the guns and the money, but we certainly have the lawyer. Casey Norman is with us. She's the litigation counsel with the New Civil Liberties Alliance. Prior to joining NCLA, she worked in the private sector as a financial restructuring and bankruptcy attorney, and she graduated cum laude from Georgetown Law, where she was the executive editor of the Georgetown Law Review. Oh my! I love it when they send me guests that are overqualified. Casey, this is wonderful for your first time on Liberty Watch. Welcome.
Thank you so much for having me.
My pleasure. Hey, the case on the table today is Dressen versus Flaherty. Tell us a little bit, give us sort of a broad overview of Dressen versus Flaherty. What's it about?
Sure. So this is a First Amendment-based case, and I believe it's the First Amendment case on behalf of COVID vaccine-injured individuals. We're representing 6 people who live all across the country in different states, and each of them was very seriously harmed shortly after taking the COVID vaccine within days, if not hours. All of them except for one, in fact. He took the vaccine and it was fine, but his son, who's 16 years old, died of myocarditis 5 days after taking the vaccine. I guess I'll just stop there to say that this is not really a science-based case. It really is, free speech and First Amendment. And what the main issue here is what happened after these plaintiffs were injured. This was in the middle of the lockdown, the middle of the pandemic. A lot of them were in wheelchairs. They couldn't leave their homes. So they went to the social media platforms like Twitter, Facebook, Instagram, and they're trying to reach out to people and figure out what is happening to me. Have other people taken the vaccine and had this happen? Just kind of sharing their personal, intimate experiences and seeking out, advice, help, emotional support from other people. And these kinds of posts were consistently, and they continue to be actually, censored on these platforms, either removed or flagged as misinformation with a link to the CDC for more reliable, supposedly, information. And we're even talking about private support groups like on Facebook, where it's just vaccine-injured people speaking to each other. And even these groups were being shut down for supposedly posting dangerous misinformation. So that's kind of the gist of the case.
Is this related to the Missouri versus Biden case, where the court has come down pretty heavily against the government's editing, shall we say, or squashing, chilling free speech about these topics?
Yeah, so I guess I'll say right here that NCLA, we are representing the private plaintiffs in Missouri v. Biden as well. So definitely connected in that way. And both cases do raise the issue of government officials and agencies influencing, pressuring, inducing these social media platforms to basically commit First Amendment violations by, censoring or suppressing or chilling certain kinds of speech and viewpoints. Our case is really, completely focused on vaccine-injured individuals and, trying to talk about personal, intimate things, share medical advice, completely not political. Whereas in Missouri v. Biden, you see kind of the more political element. You have topics like Hunter Biden's laptop story, the origins of COVID. You have RFK Jr. now who's joined that case. So we're talking about his, presidential campaign election speech. But definitely, the basis of both cases really is that the government is just heavily involved, across multiple agencies, multiple officials. It has been heavily involved in censoring people in a variety of different topics.
So this is suppression by proxy.
Right. Yeah, we call it state action, where, basically they're either working so closely with these private companies, the social media platforms, or they're pressuring them, coercing them, threatening them enough that they're almost transforming the private companies into a government arm or de facto government entity.
That's the working definition of fascism.
Yeah, it's terrifying. I mean, it's horrifying. The more you learn, the more it's just absolutely shocking.
Well, look at the bright side. They might get a merit badge from the Mussolini Proud organization.
Yeah, something to be.
Yeah, I mean, after all, I wonder if the Scouts actually have a Mussolini merit badge. Oh, well, I digress. To me, if you don't joke about it, you end up crying about it. So I'd rather, as Billy Joel said, I'd rather laugh with the sinners than cry with the saints, because the sinners are much more fun. But being realistic about it, it seems like such a slippery topic to nail to nail the jackboot of government to the planks of the First Amendment. How do you do that? What mechanism?
So it's a great question. And actually, at NCLA, we had our original case that was also kind of rooted in this issue of federal government agencies and officials censoring people on social media. It's called Changizi versus HHS. That case came before we learned so much information from the Twitter files.
Right, from Matt Taibbi, right.
Yeah, exactly. So we didn't have all of that evidence in terms of the emails, the pressure that, Rob Flaherty and other government officials were imposing on, Facebook executives and that kind of thing. But we did have enough evidence that it was, in the complaint, we're saying the timing lines up. Like the pressure all of a sudden began in early 2021 when the Biden administration took over, and you suddenly see all these certain kinds of viewpoints being suppressed. But the argument that the government put forward there was, you can't prove that this is a government. I mean, sure, we have positions. We publicly talk about what our preferences are, but we're allowed to do that. And this is private companies independently making choices that has nothing to do with us. That's not a First Amendment violation, period. And now we have all of this information. I mean, just thousands and thousands of emails where you see up to the highest levels of the White House. And you know what I mean by that.
I realize you're being historically accurate in what you're saying, but we got to watch it with that on AM radio. So please substitute what the F, if you will.
Oh, yes. Sorry. I'll keep it to.
Yeah, I know. You were quoting him, and it's not necessarily an FCC violation to quote someone using the F word if you're using it in context of what they're saying. But for instance, in 1986, the NPR aired the tapes of the cockpit when they shot down the two Libyan fighters, and the one of the pilots said, "I can't get an effing tune," and they played the whole thing, the clip, and they warned people it had profanity in it. So it's not necessarily an FCC violation, but I prefer to make it to be more sanitary about it, if you'd be so kind. Okay?
Yes.
I get it. So I dumped it. Hopefully it didn't go over the air. I used the dump button. So anyway, let's see. Vex, explain the mechanism. We got about 3 minutes before the break. Explain the mechanism of the way that government interfered in social media companies in order to cause them to censor themselves.
Sure. So you'll see a lot of this was revealed in the discovery from Missouri v. Biden, and especially in the Facebook files. But you're seeing here that the arguments the government made initially, like in that original case, Changizi v. HHS, saying we didn't instruct the platforms to do anything. We made public statements, and they maybe agreed with us. You start seeing all of these emails, all these calls, meetings, constant just reminders of why is this information up? Why hasn't this been removed? Threats. We might remove your Section 230 protections. We might change the antitrust laws, make it a little bit more difficult for you. You start seeing so much of that, just immense pressure that's weekly, if not daily, coming from these government officials. And now that this is all out in public, the government has changed its story completely, because they can no longer say, oh, we never pressured them, we never said anything, because now it's been revealed. So they're saying, actually, it is our First Amendment right as the government. We are allowed to protect the people from very dangerous speech in topics like this. And we have to be able to do this because it's essential for the government's role in public safety and welfare. So I think they're hoping that people have short-term memories, including the courts.
Casey, this is something I'm really glad I'm speaking with an attorney about. I have a tenet I've said for a long time: governments do not have rights. Only a corporeal person, no, hear me out. Only a corporeal person can have rights. Governments have authorities, and they're either lawfully executed or unlawfully executed. But governments have authorities. For instance, to give you an example, eminent domain. Government has the authority to take something with just compensation for public use. For instance, roads. Postal roads and buildings. If they need to build a post office where your house is, they can say, "We are taking this. We're going to pay you fair market value for it, but we're taking it." Government has the constitutional authority, not right, but authority to do that. It's not semantical; it's substantive. Criticize me.
Right. No, I completely agree. I mean, the First Amendment, I mean, it was not meant to protect the government. The whole point is that the government is there to serve us, to protect our rights. It's the free speech of the citizens that are supposed to be protected from government overstep. It's just an absurd argument. And they're basing it off of public safety and welfare and saying if we allow misinformation out there, so much harm will be done to the citizens, which is just absurd when you actually look at the speech that they're talking about. I mean, in this case, Dressen v. Flaherty, for instance, it is people that were harmed after taking the COVID vaccine, and often private speech, just among other people who were harmed. Like, how is that protecting the public safety and welfare when you suppress it? It's beyond me.
You know, I have 4 words for people who believe that suppressing people's speech is protecting them. And those 4 words are Freedom of Information Act. Yeah.
Right.
All right, stand by. We're at our 3/4 of the hour mark. We'll be right back after this in the Wilkinson Wealth Management Studios with Casey Norman of the New Civil Liberties Alliance. Stand by.
Takeoff. Always thankful for the crew. You doing okay today? I had to skip breakfast. A little hungry. Copy that. I got your back. Where's he going?
Hi, can I take your order?
Yeah, I'll take 2 double chubby chucks, 2 fries, and 2 double chocolate shakes to go, of course.
Thank you. Have a nice day.
Colonel, I'm back.
That was fast, Captain.
Fast food.
All right, the question is how are you going to get my order to me?
Through the probe and drogue.
But, Captain, that's what they use for refueling.
That's exactly what I'm doing.
Thanks, Captain. I got it. It's still warm. Let me tell you, I owe you.
Well, sir, you're invited to the barbecue this weekend and bring a prime rib.
No problem, Captain. I'll see you Sunday, and God bless the USA.
At Perfection Auto Works, we appreciate and honor those that give themselves to protect our freedom. From your F-16 to your F-150, 323-8650, and PerfectionAutoWorks.com.
This is Dennis Weaver, and you're listening to Liberty Watch. You know, the exchange of ideas is so important to maintain our freedom in this country, and Liberty Watch is a show that promotes freedom.
Listen to Inside Track, Saturdays 1 to 2 on KBOI, The Voice.
Hartman Glass invites you to its Gallery of Glass showroom for custom shower doors, tables, and glass enclosures. From boardrooms to an exquisite display case for your valued collectibles. Need a glass conference room in your office? Laser measuring for accuracy. 903-0766 and see them online at hartman-glass.com. That's hartman-glass.com. Swap shop trains are coming, rolling down that free market track. Sunday mornings, you can buy, sell, or trade anything lawful and moral on the swap shop. Let's listen.
Bob.
You are live.
Multi-tools. I have one in every car.
Do you have an everyday carry pack?
No, I have a paper bag in my car. My wife and I used to use that for luggage whenever we went out. You don't have to worry about a suitcase.
Swap Shop, Sundays 10 to 11 a.m. right before Liberty Watch.
So we bid farewell to Goldie the goldfish as she journeys to that big pond in the sky. Amen.
She's still there, Dad.
What?
Goldie's still there. She didn't flip.
Because Dad didn't use Picture Rocks Cooling, Heating, and Plumbing, this little pet funeral is going to take a long time.
All right. We therefore commend our Goldie once again to the appropriate place.
Still there, Dad.
Picture Rocks Cooling, Heating, and Plumbing, making sure all your plumbing is working the way it's supposed to.
And so, Goldie, we bid thee farewell.
Still there!
It's a matter of jurisdiction, the power to speak the law. It's jurisdiction that matters after all. Back in the trial court, you have an opportunity to be heard. It's the adversarial system on display and in the flesh. Hoping to a just result, the court will rise.
And welcome back to Liberty Watch. We have the joy and pleasure of having with us Casey Norman. She is a fairly newly minted attorney from 2019, Georgetown Law, cum laude graduate of Georgetown Law, also law review, editor of Law Review there. And she's with the New Civil Liberties Alliance. They have an interesting case called Brianne Dressen versus Rob Flaherty et al. It's, I guess, 6 plaintiffs, and it's regarding being suppression of free speech between of people who are sustained vaccine injuries. Speaking of which, with that song, did that song come down the phone line very well?
Did the song come down?
Yeah. Did you hear it okay?
Yeah, it was very clear.
It was a song about jurisdiction. How is it, and also it didn't say it, but standing, how is it that you were able to maintain standing before the court to say that the people who are vaccine injured, that their free speech was suppressed, that actually have a what do you call it, an articulable injury in this case? How were you able to show that to the court?
Yeah, so right now we're in the very early stages of the case. So we filed our complaint at the end of May, and that's just about all that's happened. In fact, I'm glad you raised this because the government's response deadline was, I think, 3 days ago, and they have declined to respond. So I assume that they're going to argue that.
The legal term for that is default?
I would hope so, but it's the government, and they, the rules don't really apply to them, it seems, for many of these things. Huh. So I assume that they're going to raise the standing argument, and they're going to try to say, like we were discussing in the last segment, that, you can't show that this wasn't just the independent decisions of the social media platforms to censor and flag this kind of speech. So, how do you have standing against us? It doesn't make sense. But luckily, we have, a lot of preliminary discovery from Missouri v. Biden, and like I was saying before, the Facebook files and the Twitter files. I mean, we have ample evidence of these government defendants in this lawsuit who have specifically said, to the social media platforms, why is this, vaccine-injured content here? It needs to be removed, even if it's true. I mean, they've explicitly acknowledged that so much of this kind of speech is truthful, but they don't want it on the platforms because it might, it's counter to the government's preferred policy of, everybody should get a vaccine, regardless of whatever medical conditions you have or your own free choice, like bodily independence. They don't really care so much about that. So that's what we're going to argue if the government ever does file a response to our complaint.
Huh. There is a name for this doctrine, the government doctrine. I don't know if you're familiar with it.
For which doctrine?
The doctrine that they're using to in the entire case. It's called the garbanzo beans doctrine. We have nothing better, so we just use garbanzo beans.
Yeah, that's about right.
It's the only way to avoid profanity, dear. All right, I'm sorry. You hit my seriousness limit. I just, when something becomes so absurd that dealing with it is stressful, I find that making fun of it, my grandfather, who is Judge Samuel Heller, my grandfather said that you can do so much more with ridicule than you can with being censorious. So
I agree.
He was responsible for my knowing about certiorari before the infield fly rule. Anyway, how do you fight this sewage? How do we keep the jackboot of government nailed to the planks of the First Amendment?
So I think really with these lawsuits, if you think of it, the government and these officials, I think they operated in a manner in which they didn't believe that these kinds of communications or emails were ever going to come to light or become public. Mm-hmm. And I think they've just resting on the fact that the government usually prevails in these types of lawsuits and you don't ever make it to discovery, so none of this information comes out. But now that it's out there, I mean, we're starting to get really strong footholds in these lawsuits. And I think through these lawsuits, we're finally going to be able to hold these government agencies and officials accountable, whereas we haven't really seen that before. And a lot of focus has been put on the social media platforms as defendants as opposed to the government, I think because it has been really hard to pin it on them. Mm-hmm. But now that we're making progress, I think I'm hoping that they're going to think twice. If we prevail in the lawsuit and the court says this is unconstitutional, your behavior has violated the First Amendment, unacceptable, you cannot do this. If that kind of order is out there, they're not going to have such an easy time continuing with this misconduct. So I'm hoping that this, once we make it to the end and find victory, then we're going to have some progress.
I've always wanted to ask an attorney this, and maybe it's not fair because, you haven't been before the Supreme Court yet, although I'm sure you're going to get there. Someday you're going to be the one in the dock. But yeah, I mean, that's fascinating stuff. But why do courts not write decisions such as, we hold the truth to be self-evident, the Second Amendment means what it says? They never say it that way. They say it in other artful ways. I mean, Justice Thomas did a beautiful job in New York State Rifle and Pistol Association versus Bruin of being very, very clear in knocking down what they were, what the ways that they were trying to basically delete the Second Amendment, or at least the effect of the Second Amendment. Why do courts write decisions, especially senior courts, appellate or the Supreme Court, write decisions in such ways that they create basically collateral bypasses of the Constitution?
So I can't be certain, of course, but I think it has to do with this doctrine of judicial deference. I think courts, especially when you get up to the higher levels where you're really making an impact on legal rights and statutes, I think they're very, very hesitant to make a decision that could be characterized as making law or making policy or overstepping what the judge or what a court is supposed to do, whereas the legislature is supposed to make the laws. And I think they often get accused when they become active that they're making laws. You see that with abortion cases and other cases where they're kind of, and there is a line. I mean, there's a line between saying a statute is unconstitutional, like go back to work, Congress, fix this, or, just shoot down an actual constitutional statute and saying, we don't really like that, we prefer something different. And I think it's kind of a fine line that they're treading, and there's a lot of caution that you see. And my guess is that they're sometimes hesitant to go, full force, like you were saying, because they don't want to be accused of being overly active and overstepping judicial bounds.
Of having too much energy in the court. So, in other words, if I'm listening to you with my inner ear or my intuition, what I'm hearing you saying is it's a separation of powers issue.
Yeah, and you see courts are a bit more sensitive to that, and they try to adhere to separation of powers principles, whereas you don't see that always so much with, for instance, the defendants in these lawsuits with censorship. I'm looking at the executive branch, for instance.
Refine that for me. You don't see it that much. Explain that.
I mean, when you look at the administrative state, for instance, and it's really an issue of both the legislature and the executive. But when you see the legislature kind of not making so much law and delegating a lot of its powers to these executive agencies who get to issue rules, rulemaking that kind of take the place of law, or at least hold the force of law in a lot of instances. That's obviously a separation of powers issue, and you just see kind of blatant disregard for that a lot between among the other two branches. Whereas I think among the courts they're a bit more sensitive to it, and they try not to overstep bounds. Right. But sometimes that can be excessive too, where you shouldn't just mindlessly defer when there was an arbitrary, capricious, unconstitutional statute that did require judicial analysis and review. So I think it's just really a fine line, and it hasn't been completely smoothed out yet.
There's a good book on this called Leviathan by Clint. He used to be with Goldwater Institute. He's now a Supreme Court Justice in Arizona, Clint Bolick. And he talks about the courts are not too bold. They're not too activist. They're not activist enough. His point in that book is that when they should knock something down for being unconstitutional, they lack the, shall we say, testicular fortitude, my words, not his, to do so. trying to walk the line here. And so, that's his argument. How would you juxtapose what you just said with what the broad misquote from him?
Well, yeah, I'll have to think of other creative language that I can substitute for that.
Right. What the fun?
I think
WTF, what the fun, right. Anyway, you were saying.
Yeah. So I think when it comes down to it, you see a lot of deference from the courts to agencies. And I get the reason, I get the background reason why. They say, these agencies, they are the specialists or experts in this particular area. They've done all the research. We're not going to pretend that us as judges and, of course, know more about the environment and those kinds of considerations. So we defer to the agencies. But I think there comes a point, too, where you're talking about legal issues, legal questions, whether the statute is overstepping the scope of this agency's authority. And those get mixed up in the expertise questions. And I think we've reached a point with a lot of courts, at least, where they're afraid to even address the legal questions. And it's just, okay, it's an agency issue, we're going to defer.
Well,
that's not.
I look at it in what Paul Harvey called shirt sleeve English. And one of my sponsors of the show is an automobile mechanic. And I was talking about using the right amount of torque. And torque is measured in foot-pounds. And he said today it's much more finer adjustment. He says it's in inch-pounds, a much finer adjustment than foot-pounds, which taught me a lesson. I didn't know that. And I think courts are reticent to get into the inch-pounds of things, and they want to stay away from it. I think that's the other side of the coin of what you just talked about, deferring to agencies.
Right, exactly. They haven't hit the happy medium, I guess. And it really is a fine line, because you don't want, the separation of powers principle is really important. And of course, you don't want judges to become lawmakers. And,
right.
But you don't want them to be powerless either.
It's one of the things that makes us the constitutional republic we are: the separation of powers, the judicial system, the ideas of equality under the law, and innocence until proven guilty, and the no cruel and unusual punishments. It's one of the many things that make us who we are, as well as having the ability to have a system for the registration of titles so that you can build a society on solid footing. Casey Norman, we're at the end of our time. We're actually right now at the top of the hour, but the next hour I don't have a guest, so I don't mind if we go a few seconds over. How do we get more information on the New Civil Liberties Alliance, and if people want to contribute to your cause, how do they do that? Briefly.
Okay, so we're a non-profit civil rights group, so we rely on donations from people. And if they want to help out in any way in terms of donations, our website I can provide. It is nclalegal.org. Then if you want to check out our cases too, we update all the time, almost daily, on the latest.
nclalegal.org.
nclalegal.org. Yeah.
Norman Charles Lima Alpha, NCLA.
Exactly.
All right. You are a blessing. And I hope that this is not the last time we interview you from time to time, because we can talk. You and I, we can talk. We can, as they said in Star Trek, we reach. So that was.
I agree. I would love that. That was delightful.
Yeah. And this is wonderful. Listen, I got to let you go. I'm way past, I'm a minute and 11 over for station identification. The FCC is going to swoop in on me. So you have a blessed day.
Thank you. You too.
Right,
Thanks for having me.
Yeah, my pleasure.